Thank you, everyone, for joining us today for this webinar. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the H-1B visa, which allows individuals to work for a U.S. employer in a specialty occupation. Just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different immigration law-related topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a comprehensive guide for the H-1B visa that we will be discussing today, which is a booklet of information that you can use as a reference. We will also send you a link to where you can sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button to our channel, as we do regularly upload immigration law related videos. Finally, we will send you a link that you can follow where you can set up a consultation with one of our experienced attorneys should you wish to discuss your case further. Today, we are very lucky to have Kelly Weiner, who is the managing partner of Scott Legal, who has a wealth of experience in the H-1B visa, who will be presenting about the requirements and the procedures of applying for an H-1B visa and the main considerations. Finally, for any question you may have, please feel free to add them into the chat box or the Q&A function, and we will try and get to all questions. So without further delay, I will start the presentation by going over some of the basic information about the H-1B visa. So let's start with the requirements. What are the H-1B requirements? The first requirement is that the H-1B worker has a U.S. bachelor's degree or higher level degree as required by the specific specialty occupation from an accredited college or university. Now, if the worker has a foreign degree, they can also qualify by showing that the foreign degree is the equivalent of a U.S. bachelor's degree or higher, and you would do this by applying for and getting a U.S. education equivalency report from an accredited agency. If the specialty occupation requires a license, registration, or certification, the worker must show that they have this license, registration, or certification. Now, for those without a traditional four-year degree, a bachelor's degree, there is also a way that this worker can qualify as someone who does have a degree using what is called the 3-to-1 rule. So there is an equivalency of 3 years of specialized work experience per 1 year of formal education in the specialty. So for example, if this person has a 2-year diploma and has 6 years of work experience, that could be equivalent to 4 years of formal education as required. Now let's look at the second requirement. The second requirement is that the H-1B worker has a job offer from a U.S. employer. So the entity that is requiring this position to be filled must be a U.S. company, a U.S. corporate entity. The third requirement is that the position must be a specialty occupation. And what does it mean that something is a specialty occupation? The first consideration is that for entry into this position, a bachelor's degree or higher should be normally the minimum requirement that someone should have to be able to do that job. And this requirement to have a bachelor's degree must be common in the industry. In parallel positions among similar organizations, or in the alternative, the employer can make an argument that in that particular case, the duties that are required is so complex and so unique that usually it would be required to have a bachelor's degree to perform that particular job. Now, another requirement is that the employer must normally be requiring a bachelor's degree or higher for the position. And it cannot be the fact that the employer usually hires people without such bachelor's degrees, but is, creating a special exemption for that foreign national. That will not work. Another requirement is that the nature of the specific duties must be so specialized and complex that the knowledge required to perform the duties is usually associated with the attainment of a bachelor's degree or higher. So in all of these considerations, you can see that not all occupations would really fit with the requirements for an H-1B visa. All right, so we can move on to the next slide. When can you apply for an H-1B visa, and what is the H-1B lottery? So this is a very important procedural aspect to go through because there is a limited number of new H-1B positions that can be applied for each year. So this is called an H-1B cap. So what is this cap? Each year, the number of new H-1B petitions that can be adjudicated is capped at 65,000 for a regular, what is called the regular cap petitions for those with a bachelor's degree or equivalent. And there is a 20,000 cap for those who have U.S. master's degree or higher. And it's important to note that you do need to have a U.S. master's degree or a U.S. higher degree. You cannot meet this special 20,000 cap if you have a foreign degree. So you can see that the total number of new H-1B petitions that can be approved is capped at 85,000 per year. However, each year, a lot more than 85,000 applications are submitted each year. And so how do you select the petitions that are going to be approved for the 85K? There is a lottery that is being held every year in March. And you can see here that last year, the number of applications were at 780,000, more than 780,000, which brings down the approval rate to just about 10% of the petitions, of the applications, registrations that were submitted. So there is a randomized lottery that picks among the registrations of petitions that can go forward. Now, let's talk about the H-1B change of employer petition or an H-1B extension petition. Now, those petitions are relevant once you are already on H-1B visa status. So once you are already on the status after having been selected through the CAP process, you can file a change of employer or an extension petition pretty much anytime. So you're no longer subject to the CAP once you have already been selected in a CAP. So as I mentioned previously, the H-1B lottery, it is held every year, and it is a computer-generated random selection process to select the petitions. And the reason why this is necessary is because there are a lot more registrations than there are petitions available. And since 2020, the H-1B lottery process has become fully electronic, and this is done online. Now, one thing to note is that some U.S. employers are exempt from this cap requirement. This means they don't need to participate in this lottery at all. If they have a job for a foreign national, they can submit an H-1B petition anytime. So those employers are not counted towards the 85,000 H-1B cap. And so only a select type of institutions can qualify as a cap-exempt employer. And the most common example is a university, an institution of higher education. Also, a university-affiliated nonprofit entity. So, for example, a common example is a teaching hospital affiliated with a university medical school, for example. And there must be a formal affiliation in order for those institutions to qualify as an affiliated entity. Another example of a cap-exempt employer is a nonprofit research organization. Also, government-affiliated, U.S. government-affiliated research organizations are exempt from this cap. All right, so now then let's talk a little bit about what the H-1B application process looks like. So this year, the registration period runs from March 6th to March 22nd. And during that period, the employer will submit a registration online to participate in this annual H-1B lottery. Now then, once the registration period closes on March 22nd, USCIS will run the lottery through this computerized selection process, randomized selection process that I talked about. And the applicant should be notified by March 31st, 2024, on whether they have been selected in the lottery or not. So if the applicant is selected in the lottery, the petitions will have to be filed within 90 days. So for last year, this meant that the petition must have been filed sometime between April 1st and June 30. So in order to participate in the H-1B lottery, the H-1B employer has to make an online USCIS account. And the H-1B employer can work with their immigration lawyer to prepare and submit the H-1B registration. And there is a process where these accounts are linked, and the employer and the attorney can collaborate in preparing and submitting the H-1B registration. And all of this is done completely online. Now, what is the fee for the H-1B registration? It is $10 for each registration this year. However, starting from next year, the registration fee will increase to $215 for each registration. So now let's say once you are selected in the lottery, once the applicant is selected in the lottery, what does it look like to file an actual H-1B application? The first step is to file a labor condition application called the LCA with the Department of Labor. And once that is approved, the H-1B petition can be filed. And there are two ways the H-1B petition can work. If the beneficiary is already in the United States, this can proceed as a change of status. And if the beneficiary is outside the United States, they can go through the home country consulate to apply for a visa based on the I-129 approval. And that is called consular processing. And if you get a visa stamp, then the beneficiary can use the visa stamp to, travel in and out of the United States on H-1B status. All right, so then now we will move on and talk a little bit about family considerations. Can an H-1B employee's family come to the United States? So the answer is yes. The spouse of an H-1B employee and children unmarried and under 21 can join the H-1B employee and live with them in the United States on H-4 status. However, one thing to note is that the spouse of an H-1B worker does not typically get work authorization, and work authorization is available only in very specific circumstances, as I will briefly explain in a bit. Children and spouse can study in the United States while they are here on H-4 status. However, the spouse generally cannot work. So in particular circumstances, the spouse may be able to apply for an EAD, an employment authorization card, if the H-1B visa holder has advanced to a certain stage at an employment-based green card process. So, for example, if the H-1B employee is the beneficiary of an approved I-140, that is the immigrant petition for a non-citizen worker, or if the H-1B worker is in an extended H-1B status beyond the 6-year limit. So usually there is a 6-year limit on how long you can be on an H-1B status, but this limit can be extended based on certain circumstances. And this is because there has been a new law called the American Competitiveness in the 21st Century Act, also called AC-21. So if 1 year or more has passed since the filing of any application for labor certification, or if 1 year or more has passed since the filing of an EB, employment-based immigrant petition, the I-140, or if, the person is a beneficiary of an approved immigrant petition for a worker, but is not able to adjust status because of the priority dates backlog, then in those circumstances, the H-1B status can continue to be extended based on AC-21. And in those circumstances, the spouse, the H-4 holder can apply for an employment authorization card known as a EAD. All right, so another interesting wrinkle that comes up is who can pay for the H-1B legal fees and government filing fees. And it is very important to note these restrictions just to avoid problems in the petition. So legal fees, and this means fees that you pay for us. If we handle your petition, fees that you pay for a lawyer. Generally, an H-1B employer cannot require that an employee pay for the lawyer legal fees or reimburse the employer for these attorney fees related to getting an H-1B visa. And there shouldn't really be a side agreement or anything behind closed doors of, somehow the employee paying the employer back. That is not legal. And another important note is the employer cannot take the fees in any attorney's fees out of the employee's paycheck. One exception, the H-1B employee can pay the legal fees for their dependent application costs. So their spouse application for the H-4, the children application for the H-4, if that is relevant. Now, government filing fees. Who can pay for the government filing fees? And it is important to note that for the H-1B process, the filing fees are quite extensive. There is the fee for the I-129. There is a fee called the anti-fraud filing fee. There is also this thing called the ACWIA fee, which can be quite a burden to employers. However, it is true that the employer must pay all of the government filing fees. And there is only one exception, which is that the employee can pay premium processing fees if they wish to get the decision sooner. That is one exception that is allowed. However, the employer must pay most of the filing fees that is required for the government. All right, so at this point then, I will turn it over to Kelly, who will continue and talk about the nuances, various nuances of the H-1B visa and H-1B status.
Thank you, Jiyae. Perfect. So one thing that has, come up, quite a bit is, what happens if you lose your job on an H-1B visa. Particularly, there are various kind of tech companies that went through large layoffs last year. So this is kind of a very hot topic. So always good to remember that, based on kind of recent regulatory changes in the last few years, there is now a grace period that's available. So if you're here on the on an H-1B visa and your employment terminated unexpectedly, or you decided to leave your job early, the first thing you want to do is check your I-94. So if your I-94 is valid, let's say for another year, you will be able to get your full 60-day grace period. If let's say, you quit your job and there was 30 days left on your I-94, then, you have a 30-day grace period. So it's going to be 60 days or less, depending on what is on your I-94. And then during this time, you have a few options. So obviously one option is you could depart the United States. Another option is you could look for a new job and have a new employer file a change of employer H-1B petition for you. And you are able to do this, during the entire 60-day grace period. So you do have, that time to kind of look for a new job, see if they can file an H-1B petition for you. And if they do, then under the portability rules, once the petition is actually filed and has arrived with USCIS, you can go ahead and start working. Up to when they make the decision. If they approve it, you can just continue working. If they denied it, then, obviously at that point you would need to stop working. Another option is to use that 60-day grace period to change to a different visa status. If a different visa status is available to you, so for example, if perhaps you don't intend to keep working in the US, but you just need some more time to wrap things up, change your housing, things like that, you could, change your status to, B status as a tourist. Or if perhaps you're in a position where maybe you want to switch to another visa type, maybe you want to switch to an E2 visa, for example, and start your own company. You could potentially, file for a change of status to E2, or you could file for a change of status to a B1 business visitor to give yourself some more time to investigate those opportunities. So the important thing is that if you do decide to stay in the US, you would need to file a petition either to work for another H-1B employer or change your status to a different status before your 60-day grace period ends, to ensure that you, are maintaining your status in the United States. So let's talk a little bit more about the 2 grace periods. So we just talked about the 60-day grace period. So this is a really great benefit that was not available before. It used to be the case that if you lost your job on H-1B, the next day, you were the day after you stopped working, you were no longer considered in status and needed to depart the United States right away. So the 60-day grace period gives a lot more time to figure things out, and to remain in the US, and not be violating any status. It is important to remember this is a discretionary benefit. So that means that the government does have the ability to eliminate or shorten this period. You also cannot work during this grace period unless you have a petition that was filed on your behalf that properly allows you to work, for example, under the portability rules. Another grace period that is relevant is this 10-day grace period. And so this is a bit different than the 60-day grace period. So that 60-day grace period only comes into play if you're leaving your employment, either by being terminated or quitting, earlier than planned, and you still have time on your I-94. The 10-day grace period is something that, basically allows you to enter the United States, 10 days prior to the validity of your H-1B employment, and also tax on 10 extra days at the end of your validity period. So if you have a 3-year validity, but your and your LCA, it ends, February 6th, but your approval notice gives you status through February 16th. That's that 10-day grace period that's been added on there. It is important to note you cannot work during that period of time. So you're still in status. You could file to change your status, or to change your, to a different employer. But if you're just here on that 10 days, you shouldn't be working during that period of time. You need to have the H-1B petition and the actual LCA covering that time frame in order for you to work. So how many times can you renew an H-1B visa? So generally, you can be granted the visa for up to 6 years, in 3-year increments. Only time that's spent in the US counts towards these 6 years. So sometimes, for example, let's say that you went, abroad for a month every year to visit your family. It may be that as you're getting to the end of your H-1B time, you can add all of that together to get additional time if you are, looking for other visa options or waiting to change to another status or waiting for a green card application to come through. So it is important to kind of keep track of your I-94 travel history. Also, you can keep plane tickets, other proof that you passport stamps, any kind of proof that you have that you've left and been outside the United States. That is very useful for recapturing time if you're getting close to the end of the 6 years and you need that extra time. There's also, as Jiyae, discussed earlier, there's exceptions under the law that allow for extensions beyond the 6 years if you are in the green card process. So in the process of getting a permanent, green card to stay in the United States. So there's kind of a couple different, options here. One is called the lengthy adjudication delay. That's where you can get extensions, for 1 year if 365 days have passed since either the filing of a labor certification with the Department of Labor or the filing of an immigrant visa petition. And you can keep getting those extensions up until kind of a decision is made. So if there's an approval, great, you can keep, working on that. If there's a denial or the petition is revoked, then you can't get extensions based on that. The other way to get extensions is through something called the per country limit exemption. So this is where, let's say you've got your I-140 approved, but your priority date is not current yet. And on the visa bulletin, there's still going to be several years, until you can actually file for your green card. At that point, you do have the ability to file for 3-year extensions to your H-1B status, and you can continue to file these extensions up until your priority date becomes current and you're able to actually apply for your green card. All right, so I think, this slide is addressing a very common, misconception that you have to be on an H-1B visa to apply for a green card. So no, you don't. You do not need to be on an H-1B visa to apply for a green card. However, there are many benefits to being on an H-1B visa during the green card application process. So for example, perhaps somebody's here on a TN visa. The TN visa has a very high standard for proving non-immigrant intent. So it can be trickier, it can be more difficult to switch from a TN directly to a green card. The H-1B visa allows for something called dual intent. So this is where there's no issue, no conflict with applying for or having an H-1B visa and also simultaneously applying for a green card. Whereas with many other non-immigrant temporary visa categories like a student visa, that TN visa, you have to prove that you intend to return to your home country. For the H-1B, that's not a concern. So that's one very large benefit you get for the H-1B is you just don't have to be concerned about travel, about renewing your visa. If you're in the green card process, if they ask, so you're pursuing a green card, it's okay that you are because it does allow for dual intent. In certain circumstances, you can even travel on the H-1B while your green card application is pending, which is another large benefit. So let's say you are here on a TN visa and you file your green card application, an I-485 adjustment of status application with the government. At that point, you're not permitted to travel. If you travel, you will abandon the application. You would have to wait at that point for your travel authorization to be approved. So you can file for travel authorization with the I-485, but the travel authorizations right now are taking several months to be approved, even up to and sometimes over a year. So with the H-1B, you don't have to worry about that. As long as you are continuing to work for your H-1B employer and you are on H-1B status at the time, you filed your green card application, you can travel in and out without worrying about abandoning the green card application. So that ability to continue traveling without a break, is a nice benefit. And then as well, the other benefit for the H-1B is if your immigrant visa category is backlogged, there is a process for extending the H-1B while you wait for that immigrant visa to become available. So, even though, for example, on a TN visa, that can be renewed in increments of 3 years, and definitely there's no time limit on it. But once you have an I-140 filed, and if your priority date is really soon, like you'll be able to file for a green card, pretty soon, renewing the TN can become a bit tricky. Because when they ask you questions about what your plans are and what you plan, do you plan to return to your home country, they may not be convinced. Even if on your I-140 you indicate, yes, I plan to go to the consulate and process abroad, there's some officers that just will feel that your intent is not temporary and therefore you're not eligible for this TN visa anymore. So being on the H-1B can be helpful in that regard because if there is a long backlog, there is an ability to continue extending, the H-1B visa as long as you've reached a certain part of the green card process. All right, so let's talk a little bit about the green card process going from an H-1B to an employment-based green card through the EB-2 or EB-3 process. So I'd say the most common way this happens is while you're on an H-1B, your employer decides they're going to sponsor you for a green card. Very frequently this will happen through something called the PERM process. So the PERM process is an employer-driven process. So this is where the employer is required to test the U.S. labor market to determine if there's any willing, qualified, or available U.S. workers for the position you'll hold when you get your green card. So it's not really the H-1B position and the green card position might be the same, but they don't have to be. If there is, so for example, if your employer says you're an engineer now, but we want you to be an engineering manager for the green card. So the PERM process will be about testing the U.S. labor market for that engineering manager position. So if they don't find any willing, qualified, and available U.S. workers, then the employer can file something called a labor certification with the Department of Labor. Those are taking about a year right now to get a response. It can either be certified, meaning approved, or it could be audited, meaning the government wants more information. or it could be denied. If it is certified or approved, then the employer will file Form I-140, which is the petition for an immigrant worker in the US. They'll file that with proof that the employer has the ability to pay the prevailing wage, so the required wage, and proof that the employee themselves meets all the requirements for the job. And then if a visa is available, the employee can also apply for a green card through the adjustment of status process, or could also apply, for the green card through the U.S. consulate, so through consular processing in the country that they most recently lived in prior to moving to the United States. This is a very brief summary of what the green card process is. We also have other webinars that focus specifically only on the green card process. So if you have more questions about that, I would encourage you to sign up for those webinars as well. So do you have to prove that the company cannot find U.S. workers for an H-1B? This is something that, people I think sometimes conflate or confuse the perm process with the H-1B process. So although this is a requirement for the perm that you have to test the U.S. labor market and determine there's no willing, qualified, and available U.S. workers, in a normal H-1B process, this is not part of the visa application process. There's only some particular employers, so H-1B dependent employers, meaning there's a certain percentage, of workers who are on H-1Bs in that company, or willful violators, so people that are, not following the compliance requirements of the H-1B program. And for these particular subset of employers, they must attest they're not going to displace U.S. workers and must take steps to recruit for U.S. workers. But again, this is a very small subset of employers. In a normal H-1B process, you're not going to be, having to go through that process. It is a requirement for the perm, but is not an H-1B requirement. All right, so I think we've reached the end of the presentation. So we will look and see if we have any questions. Someone's asking, hi, if you change a job and the new employer files a new petition for transfer of the H-1B visa, are there costs on the new employer? Yes. So there would be, assuming the new employer uses a attorney, then yes, there'd be legal fees for filing the change of employer petition. And then as well, there are also government fees that have to be paid. So, yes, unfortunately, the fact that you're transferring doesn't mean that there are no fees. There are still fees that have to be paid to the government and to an attorney if you're using one.
All right, it seems like that's all of the questions that came in today. Thank you, everybody, for your participation. Hope this was helpful. And thank you, Kelly, for sharing your expertise.
Thank you. Have a nice day.